seen a lot of old faces, old friends. For those who know us, welcome back. For the people that have come for the first time, welcome to Greenway for the first time. And hopefully this is the commencement of a long association where you share with us as we explore new areas of law and try and learn together. This is a red hot topic, no pun intended. Let me start with a little levity because it's going to get fairly serious fairly quickly. Jean Cocteau, the great French poet, playwright, actor, filmmaker, man about town, was once asked, if your home was on fire and you could take one thing, what would you take? And he said, the fire. My own home burnt down with my 3 young children in it many years ago. The oldest was 5, the youngest was 2, still in a crib. They were downstairs in a 2-storey house, unawares that the roof and upper storey was burning while they were downstairs watching television with the young teenager who was looking after them that night. She realised that the house was on fire when the roof collapsed, partly collapsed into the building, narrowly missing the crib where my young 2-year-old youngest was asleep. With the greatest courage, for which I'm always thankful, she managed to get the children out of the house before the roof finally collapsed and the house burnt down. I was lucky, I didn't lose everything. I was able to take my children away with me. This experience may explain why I take fire safety in a building with a particular personal view. It's a personal matter to me, and I find it difficult to examine the issues that we're going to examine tonight with a pure objective legality, which I trust I've developed over the years by dealing with construction issues. The story that I'm going to tell is well known. It's been told in various newspapers, various articles. It's really the start of the story that we're going to tell tonight. But the story is the epitome of tragedy, and it's tragedy writ on a really large scale. It's pretty well known now. It took place early on a Wednesday morning. On the 14th of June, it will be 2 years ago. It took place in a public housing estate with 1,000 public homes in North Kensington. For those of you who know London, that's on the western fringe of inner London. It has areas which are housing estates, and there are those bits which are and have become really quite fashionable. And what I'm going to say is going to become relevant. The former Prime Minister, David Cameron, lives in that suburb. The fire started in a Whirlpool brand refrigerator. Probably, although it's not clear, probably a power surge in the building's decrepit and ageing electrics was to blame. The first fire brigade arrived within 6 minutes. The refrigerator was on the apartment, in an apartment on the 4th floor. The crew made its way in, got up to the 4th floor, put out the fire fairly quickly. Things were going smoothly, but they were going to get really very much worse. As they left the building, someone noticed crawling up the outside there was a flame making its way along the exterior cladding. From the reports, the flame was described as having moved or moving at a terrifying rate. Those of you that have seen it, this probably is worth watching. Nath, can you assist? Thank you. I'll let it run its course.
Yeah, hello, hi, in the fire, flat 16 Grenfell Tower.
So you fire where?
To the flat 16 Grenfell Tower.
The fire brigade are on their way. Are you outside?
Yeah, I'm outside.
Yeah, well the fire engines are on their way. Just tell me how many floors you've got there.
It's 4th floor.
Right,
Alright,
okay.
quick.
They're on their
It's
way
burning.
already. Yes, I know it's burning, but they are on their way. You've only just called, as long as you're okay. Yeah?
Okay.
You can see the fire on the floor inside the building, nothing on the outside.
Okay, so the house That's going, they need to get up there, that's not good enough.
Look, at Grenfell Tower at like half one in the morning, fucking hell, fire, and that's getting bigger and bigger. People are gonna die, and I'm scared.
Mate, you see that shit fall off? Wow. Go, go! Wow. It's going to go right to the top of that building, isn't it? It's gone all the way.
That's what we're all worried about. The building had one stairway. That's because the regulations didn't require a second one. So the people were trapped because they couldn't make their way down the stairway. It was filled with fire and smoke. Had no sprinkler system. The regulations in England don't require it. Therefore, no one thought about putting it in. People say that won't happen here because our buildings are designed differently. We'll deal with that in a moment. At the end of the day, that fire took 250 firemen, 70 fire engines and 60 hours to actually put out. 71 people died, at least that's the official count, but lingering doubts remain because it said that there were itinerant subtenants, asylum seekers, migrants who are all inside and probably not accounted for and will never be accounted for. Leaving aside the legalities, it's simply not acceptable no matter what caused it, no matter why it happened. And tonight we're going to discover why it happened, and we're going to discover why people are concerned and why we have a very large problem on our hands and why most of you are going to be involved in having to give advice at one time and another in the near future about this particular issue. That's what it looked like. It was designed in the brutalist fashion, brutalist architecture, rugged, not a homage to light or air or pleasantness. The sort of structure you would never have in public housing, but that's what they put up. It was a council building that was managed by a tenants association for underprivileged people. It's 24 stories in height. It was designed in 1967. No doubt the architect thought it was a great building. And as I say there, it has one staircase and it had no sprinkler system. This is what happened to it. The facade was probably getting old. When facades get old, the joints tend to deteriorate and leak. And the really cheap way of doing it is to put up cladding to provide a raincoat. It's cheap, easy to put up, sometimes works. And one view that you can have is that that was put up because the building was old and it needed a facelift because it was leaking. The public documents actually paint a different picture and probably provide the real justification, which comes back to David Cameron and his boys who lived in the suburb, because the public planning documents say this, quote, "The changes to the existing tower will improve its appearance, especially when viewed from the surrounding area." So those people who lived in the nicer bits wouldn't have to look at that. They were looking at that. The panelling there was composite panel. It was aluminium composite panel. I'll tell you what that is in a moment. And it had an architectural advantage. You can see it there. Its facings are coated. It's a sandwich. The outside bits, the bread, are steel or aluminium, in this case aluminium composite cladding. The internal bit is insulation. It's usually a foam or a filler of some sort, and that's where principally the vice is. That's what composite panel is. It looks okay. You see it all around. You drive up the Pacific Highway, you drive along Parramatta Road, you drive anywhere, you'll see that sort of look. It's modern and it looks good, but you can't tell what it is from the outside. The building on the right could be steel, it could be aluminium, it could be filled with fibre, it could be filled with all sorts of things. Makes sense as a building product. In Victoria, David McAndrew will speak about this. Victoria, there's currently litigation, he'll tell you all about it, where something like, what, $9 million, Dave? $9 million?
To replace the cladding, yeah.
$9 million claim currently is making its way through the Victorian Tribunal. He'll tell you about that. I put that up because that's a fantastic quote that comes out of the builder's defence, which is just gold, as David would describe it. It justifies the use of what was used. It was called Alcobest. Probably wasn't that, actually, when you look at the material. It was probably an incorrect brand, but leave that aside. They try and justify it as follows. The use of Alcobest in buildings of this type has been a common practice across Australia for at least 40 years. They get comfort from it. I don't particularly get comfort from it. In 2015, this gives you an idea of the magnitude of the problem we're dealing with. In 2015, the Senate referred an inquiry into non-conforming building products to the Senate Economics Reference Committee. Part of that then transmogrified into an inquiry into cladding. And this is what the interim report says. The committee notes the concern from witnesses and submitters that non-compliant use of cladding is widespread, and there have been extensive delays in developing and implementing policies to address non-compliance and non-conformity in the building industry. Okay. What I put on the screen is a cross-section of the composite panel that was actually used on the Grenfell building. On the left, composite panel, it's this bit. There was an insulation layer between the composite panel and the actual face of the exterior monolithic building that you saw, and there was a 50mm gap. The forensics tend to suggest that that gap acted as a chimney to make sure that it burnt even better. And so the sandwich panel is this bit, has the two chutes, and inside you have the insulation or filler, which can be any of this. That's probably not combustible. I say probably for a reason I'll explain, but the rest of them, probably in order, are very combustible. And the combustion, polystyrene and polyurethane in particular, the use of that in building and in various uses, and the fire hazard that it presents has been well known for a long, long time. This is not new science. I was looking at a Department of Labor report on the use of polyurethane in ships, which described the danger and the inherent fire risk, and the fact that if it caught alight, it was going to spread rapidly, producing very toxic gases, smoke, and the various difficulties. That was in 1989. And while we're dealing with what we know, if designers had bothered to look at the literature, they would have discovered that as early as 1991 in the UK, there had been a couple of incidents, one in the UK, one in Scotland, of buildings that had been burnt and where the investigations had shown that cladding was implicated in the issue. The Grenfell Tower really consolidated the view about cladding, but it was not by any means the earliest, and not by any means the biggest. It was certainly the most tragic because of people lost their lives. But I'm going to show you just snippets of other fires, some of them very dramatic, involving the same mechanism. Mostly in Dubai, one in France, and the one, of course, that David will speak about, which is the LaCrosse building in Docklands in Melbourne. Nath, these videos, can you just do something with this? This is in October 2012, 5 years before the Grenfell Tower. It's on the fourth floor it started on the fourth floor of a building. It's a Tamworth Tower. The characteristic burn is the same. You'll see it's burning on the outside. No one died. One would wonder whether that was by good luck rather than good management. Nath, this is another one. T-Com Tower, again October 2012. Nathan. And you'll see bits falling off, which is the cladding as it disintegrates with the panels coming off. It's pretty significant because when designers design, they design for fire egress, and I'll deal with the particular issues, and we could go on and on. There's Altea Tower. I won't play the movie, April 2012, but you can get an idea of just how significant that fire was. France, May 2012. This is instructive, but by reference to the speed. The panelling is on the inside walls, like the LaCrosse building that Dave will tell you about. Just have a look at what we're talking about when we talk about rapid rate. You'll see how it spreads from one to the other. This is, those of you that have been to Dubai, Burj Khalifa is just on to the left, to the right of the photographer as he's looking at that. It's in the same area, approximately 100 metres from Burj Khalifa, the tallest building in the world. This is the, oh, Nath? Sorry, can you play that? This is the address, one of the prestige hotels of the world. It's on New Year's Eve, 2016. Sorry, 2015. Do you get the idea? The unfortunate named Marina Torch building in Dubai. Nath?
Samir Fatullah is in front of the burning building right now. He's joining us now from Dubai. Samir, tell us what you're seeing, what's happening there around you.
Okay, at the moment there is about 30 apartments on fire. You can hear the building cracking. The pieces falling from the building on the car park, which is next to it.
Again, the debris falling off. Again, symptomatic. They're all the same.
Samir Fatullah.
This is the LaCrosse building that David is going to be speaking about in Melbourne. That's 25 November 2014. It broke out on a balcony of apartment 805. It's a 23-storey building. It's in Latrobe Street in Docklands. The fire spread along the balcony walls vertically downward to apartment 605 and went up the building, and you can see what happened. The walls were made of Chinese manufactured aluminium cladding panels. Now, the 137 owners of that building are currently suing the builder, the certifier, the architect, the occupant who allegedly started it. David will tell you about the seventh respondent to those proceedings, and virtually anyone they can actually figure out, get their hands on, because we're talking about replacement costs when you have to replace this stuff of between something like $50,000 to $70,000 per unit. Macquarie Street last week, we had a fire in the scaffolding and the sheeting of the scaffolding. They told you about the fire. What they didn't tell you is that scaffolding is up for the purposes of replacing the cladding in that building. Today we'll talk a little bit further about the link between the panelling and fire and why we're in this particular predicament. But you should know just how big this problem is. I gave you a snippet of that by reference to the Simon statement in the LaCrosse proceedings and the interim report from the Senate, but I can indicate to you that in the UK, the Grenfell fire disaster was insured for £20 million, £20 million. That's going to be consumed by far. And the current economic estimate in the UK, the outcome of that fire, because of the flow-on effects it has, because people are now galvanised into saying, crikeys, we've let this go long enough, we've got to replace this stuff, is probably £1 billion when one looks at demolition, reinstatement, the deaths, compensation, rehousing, so that there is a huge problem on our hands. In Australia, we still don't know quite how large this problem is, because after it was discovered in a hospital in Queensland, they ordered an audit. New South Wales is currently doing an audit, and Victoria is doing an audit. Estimates have put the number of buildings in Australia with non-compliant cladding at about 2,500. That's been doubted. The New South Wales government said it's not quite that much. But what you can be certain about is that as soon as the audit is done, the government will require this non-compliant cladding to be replaced. That they're doing it in Victoria, and they're going to be doing it in New South Wales. A question of not if, but when. And that's why I say that we're here today to try and assist you in knowing at least the basics, so you can intelligently discuss the issue when, not if, you're ever asked to advise on the issue. The current regulatory regime that applies to this is the National Building and Construction Standard, the Code, which is now adopted throughout Australia. It incorporates the plumbing code in Volume 3. The BCA is part of Volume 1 and 2. And the building code is the building code, which is performance-based. Let me just give you a potted history of the reforms that ultimately led to this as being the standard used throughout Australia. It commenced its life, there were 3 reform phases. The first reform phase was the adoption of a BCA which was very prescriptive. It provided what a building had to have, and if it wasn't in the book, you couldn't have it. The problem with that approach, you wouldn't have had this, but the problem with that approach is that it stifled innovation in construction. It was very formulaic, and either you came within it or not, and people had the view that you could actually do better, you could move on, you could have innovation and easy and better ways of doing things. So the second phase of reform involved the amendment of the BCA from its prescriptive model to the performance-based model that we now have, and has now taken its place in the National Building and Construction Code. And it's beyond tonight. It would take me quite a while to explain how it works, but essentially those of you that have functioned with it know that there's a deemed to satisfy provision and there's an alternative solution provision. There are functional requirements that prescribe what a building must have. Building must be fireproof, it must be safe. It then prescribes, by way of doomed to satisfy requirements, what it can have, and if it has those things, it's deemed to comply. If you don't like that, you can try and put forward an alternative way in which to achieve the function, which is the alternative solution, and you then prove that by expert opinion and provide evidence in a way that's prescribed by the building code and various other pieces of policy and instrumentation. And so when people design a building, as I say in the last bullet point, it's usually a combination of both. I don't know of very many high-rise apartment buildings which do not require some modification of the doomed to satisfy by an alternative design approach. So I've said there that in practice most buildings meet the requirements with a combination of doomed to satisfy and alternative solution. They're the principles for fire. The main structural elements of most buildings are able to withstand the effects of fire. That has to happen. Requirements must be to reduce the potential size and severity of a building fire. You have to limit the spread of fire through openings and fire-resisting construction. And you have to have an efficient and effective means of escape for the occupants. I mean, that's just basic common sense. And it leaves it to either the doomed to satisfy or alternatively the alternate solution as to how you achieve those requirements. The broad functional statements which you need to comply with, for example, CF1 requires a Class 2 building, and a residential apartment, multi-storey residential apartment building is a Class 2. I'll tell you why that's important in a moment. And it requires various safeguards. And there they are there. I won't read them, you can all see them. So they're the basic functional statements which you have to satisfy as part of the design. In a very convoluted way, the BCA, by reference to type 2 buildings, takes you to a table, and depending on the number of floors the building is, it tells you whether the fire requirements have to be a category A, category B, category C, and then it tells you where you find what the minimum fire requirements for a category building are. And clause 3.1 says this, quote, the fire resistance of building elements in a building required to be of type A, multi-storey building generally is a type A, each building element listed in a table, table 3, and any beam or column incorporated in it must have a fire resistance level not less than listed in the table. Fire resistance level is a level which is determined by standard test to ensure a duration of the element to withstand fire for a particular time period, usually 60 minutes to 120 minutes, depending on whether it's load bearing, where it is in the building. There's a complex table, I'm not going to go through it, but the fire rating is time dependent, and it is based on what it is and how long it has to resist the effect of fire. Here's the problem. When you look at the table, it makes it pretty plain that an external wall has to have a 2-hour fire rating. And that's why most external walls, all external walls of a Class 2 building, are concrete or masonry. Makes sense. Grenfell Tower was masonry and concrete. It stands to reason that if you have something attached to the wall, either it is the external wall or is not the external wall. this particular issue has been exploited by those that have advocated for dealing with external finishes with the cladding which we're dealing with here. Let me explain why. When I go to the table, which I've got in front of me, I read external wall, bracket, including any column or any other building element incorporated therein. Does incorporated mean part of the matrix? For load-bearing parts, X rating. For non-load-bearing parts, Y rating. So I read that and I think, well, the table itself connotes that an external wall can be partly load-bearing and partly not load-bearing, because I've been given a fire rating different for each element. So that's the first question. Should the cladding in Grenfell be regarded as a component of the external load-bearing wall or facade and therefore part of the system? In other words, are people misconstruing this? And I'll indicate to you that they are. Why? Because the building code, as I've set out in bold on that slide, specification C1.1 permits the use of combustible products. They're defined, and I can assure you, aluminium cladding of the type we're talking about is a combustible product, as an attachment to external walls in a high-rise residential building, as long as certain criteria are met. This one, which refers to 1.10, deals with testing, as to how you test and how you test the matrix and fabric of that material to ensure it is fire retardant. In other words, that it does not propagate fire. It's a panel that you test, and it's tested to a particular Australian standard 1530.1. Look at this. This is the one that I'm interested in. Just pause a moment with that last item. There are two really interesting things. Firstly, irrespective of the testing, it does not otherwise constitute an undue risk of fire spread, and the element seems to be distinguished from the facade. The terminology here seems to suggest that whatever this deals with, it deals with something attached which is not the facade. But this particular little baby is what developers, designers, those involved in passing buildings for construction have used to justify the attachment of decorative panels using combustible product. That's a real problem. And that explains why a lot of buildings have passed muster, have made it to the actual construction and completion with combustible materials. That has two problems, really. If you go back to the fire rating of an external wall is time related. This isn't time related. This deals with three particular indexes, which deals with the way that fire transmits along the actual panel, the amount of smoke that it produces, and how much time it takes to ignite. But it's not dealt with as a system, which is the way that external walls, load-bearing and non-load-bearing, are dealt with. And when you look at the literature, when you look at the various things that are being spoken about, this is what people refer to as being the gap in the regulatory regime. But if you just pause there, assume that I'm wrong, and assume this is actually a provision of the code that allows the attachment of decorative panels to the exterior facade of a building, so long as they are, if they're combustible, C110 requires a particular form of testing. You're not getting that for imported product. Imported product isn't tested to Australian standard. If it comes from China, it's tested to Chinese standard. If it comes from Malaysia, it's tested to Malaysian standard. And generally what's provided by the manufacturer is a certificate, which may or may not be authentic. That's a problem. Which may or may not actually certify that it's fire resistant. Which people may or may not understand, generally don't understand. And because they don't understand the code and the complexity of this code, they take a manufacturer's certification that the product is safe to use as an exterior cladding as being safe because it is either not combustible, if they even understand the concept of combustibility in this, or alternatively, that it's been tested and allowed. Now it's this particular gap that building surveyors are really concerned about, because under the regulatory regime that we apply in New South Wales, David will speak about the Victorian system, a principal certifying authority cannot issue a construction certificate unless the building complies with the Building Code of Australia. Imagine how would a surveyor, building surveyor, possibly assess plans on their face that show a requirement for composite cladding to form a view as to whether or not it complies with the Building Code of Australia without asking for the testing, without forming a view about whether or not this is permissible. And generally, people have done this in this way because they've got away with it. Let's be serious about it. It's been used this way for a number of years. The Grenfell Tower and other disasters, including the LaCrosse building, has woken people up, and the authorities are now looking at this very issue and determining whether or not people have been rorting this particular system. That's what it says. You saw the material falling off the building. Problem is that in the design of buildings, as I've said to you, alternative solutions are usually part of the process, and alternative solutions in relation to the location of exits, fire exits, where they are in the building, usually involve an interplay of facade and exit, and often the alternative solution ignores or assumes the combustibility of the material complies. David's going to speak to you about that, and he'll speak to you about the Victorian legislation and give you some idea about the causes of action. I'll say a bit about that, the New South Wales view in a moment. Dave?
Good evening, everyone. What I'd like to do tonight is stop that video, is to have a talk about the LaCrosse building, the structure and the parties that were involved in its design and construction, and then talk a little bit about the fire, how that occurred, and then talk about the events that followed the fire. There were steps taken by the regulatory authorities to deal with it. And then I'll touch on, as Franco said, some of the legislation, key legislation in Victoria. It's pausing there. In Victoria at the moment, they are proposing a class action in relation to this, so hopefully some or all of you will be involved in that. The building, which has just appeared on the screen, is a 21-storey residential building in Docklands, which is just on the fringe of the CBD in Melbourne. It's a building that comprises suspended reinforced concrete floor slabs and a reinforced concrete load-bearing walls. It was constructed at a cost of approximately $100 million. The architect was Fraser Eilenberg. They were engaged in 2007 by the developer. The architect was engaged to provide the full range of services as head consultant and as the designer, in the role as head consultant managing the sub-consultants, including the fire engineer. The preliminary specification and the ultimate specification, for that matter, prepared in 2008, called up ACP cladding, aluminium composite panels, in a generic sense. It didn't specifically identify any particular brand of panel. In particular, the cladding was specified for the balcony walls, and that's where the fire started, and I'll come back to the fire in a moment. L.U. Simon was engaged by the developer under a design and construct contract, and it was required to construct the building in accordance with the developer's preliminary design prepared by the architect, and to also comply with the requirements of the BCA and the building permit. Under the L.U. Simon specification, it was required to submit all materials for approval to the superintendent before it was permitted to proceed with the work. That becomes relevant when we talk about the proceedings shortly. There was a fire engineer engaged, Thomas Nicholas, to prepare a fire report, engaged by the developer. Fire engineer subsequently novated to L.U. Simon. That fire engineering report, rather unhelpfully, said that the panelling, the cladding, was to be non-combustible, without going into any analysis of the specification, if you can call it that the architect had set out in the drawings which referred to ACP panels. The surveyor was Mr. Galangos. He was engaged by the developer. He too was novated to L.U. Simon, and he was responsible for issuing the building permit pursuant to which L.U. Simon undertook the building works, and in doing so approved the design of the architect and the fire engineer report. Construction commenced in 2010, about July 2010. The fire engineer says that at no point in time prior to the commencement of construction was it given a sample of the cladding. The architect was provided with a sample of the cladding, and wearing their black skivvies indicated that they approved the colour of the cladding without further comment. And then in June 2011, the superintendent, pursuant to the specification, was provided with a sample of the cladding and said, the architect says it's the right colour, all good. Construction was completed in December 2011, and the occupancy permit was issued by Galangos, the relevant building surveyor, in June 2012. The fire occurred on the 25th of November 2014. The Metropolitan Fire Board in Melbourne has reported that a gentleman by the name of Monsieur Jean-Francois Gubita started the fire by butting out what he says was a late night cigarette. He alleges it was a cigarette, and leaving it in a plastic container on the balcony of apartment 805. Within the Frenchman's plastic container was some aluminium foil containing a small plant. John was on a working holiday visa. Let's have a look at Jean. That's the seventh respondent in the VCAT proceeding. Although his recollection may have been somewhat hampered, John claims that he smelt smoke. So he checks the kitchen and made sure the gas stove was off and went back to bed. Sometime later, he was rudely and abruptly woken up by his housemates. They discovered that the balcony adjacent to his bedroom was ablaze. He's still asleep. They were then very, very keen to put out the fire. They were unsuccessful in putting out the fire with another container which contained, allegedly, water. fire crews responded at 2:42 a.m. in the morning. Within 5 minutes, the fire had gone from the 5th floor balcony of Jean's to the 21st floor. So as we saw in the videos that Franco showed us before, these panels ignite very quickly. I think we might go to the fire if we can, Nathan. The footage at 7 minutes to 7:26.
The first crews arrived within 5 minutes. They were expecting a fire in one apartment. They couldn't believe what they saw.
This was outside the building. It was burning on 5 or 10 floors. This was completely outside of anything that we were prepared for or expecting.
Thanks, Nath.
There was actually a moment of absolute silence in the truck.
That'll do, Nath. We'll go now to 11:25 to...
Erickson was one of the first responders.
Sorry. What I'm going to do now is show you a little bit of footage of how Jean set the building on fire. It'll show us the balcony where the ACP panelling was located. 11:25, Nath. It looks like it.
On a working holiday, came home late, had a cigarette, and thought he put it out in a plastic container.
We had outdoor furniture, we had lots of combustible items.
The fire brigade made a graphic reconstruction.
So we had, in this case, a table and chairs and lots of things around it.
There's that panelling there.
As we know from the fire investigation, there was a plastic yogurt container that was being used for cigarette butts. That started a fire onto the timber furniture. Fire got in behind the air conditioning unit, and then the panel ignited. And with the ignition of the panel, we had flames shooting up the side. So the fire actually spread from one level to another and continued on up the building.
This shows how the fire spread up the building from balcony to balcony.
What's really striking about it was actually the fire progression that progressed, up to...
Thanks, Dave. So, following the fire, in April 2015, the Metropolitan Fire Board undertook prepared an incident report, and in doing so, went to the CSIRO and asked the CSIRO to perform combustibility tests. The relevant standard that Franco referred to, AS 1530, was employed. The product that was applied to this building had a PE composite which was 100%. There was no fibre or other fire retardant material in the ACP. It was 100% PE. The product failed miserably. Nath, if I could go to 2302. Sorry, Jean. Go back a frame. Do I need to do anything? Well, maybe we'll come back. We'll come back to it then if you can keep trying to locate it. Anyway, the CSIRO performed these tests, and it performed so badly that they were concerned that they were going to burn down their lab. It had to be terminated at 93 seconds. Sorry, it was flaming at 55 seconds, and they had to terminate the test at 93 seconds to prevent damage to the lab. So how many other ACP clad buildings are there in Victoria? There's been some audits undertaken, interim audits undertaken. At this stage, we know that of the 170 buildings that have been audited in the CBD area, 101 were non-compliant. Which is quite a remarkable percentage of buildings. I refer you to, if you're interested, the Victorian Cladding Task Force interim report of November 2017, which deals with the incidence of ACP cladded buildings. Now, as I said to you before, at the moment there is a class action being proposed in Victoria, a $4.2 billion class action on behalf of about 250,000 owners and residents of about 1,400 apartments. That class action procedure, if it launches, will be undertaken pursuant to Part 4A of the Supreme Court Act of Victoria, which, for all intents and purposes, mirrors the federal court system. The class action will target, no doubt, firms such as Hickory Building, Hamilton, Merino, LU Simon, and so on, ProBuild. After the fire, the regulatory bodies in Victoria thought, well, what can we do about this? The first thing that happened was the municipal building surveyor issued a direction to the owners of the building to rectify the remaining cladding, i.e. replace it with compliant cladding. LU Simon intervened in relation to that direction and took the matter to what we call in Victoria the Building Appeals Board, and they said that there should be an alternative solution employed rather than replacing all of the cladding, which would be involving the installation of additional sprinklers on balconies and imposing rules around the excessive storage of things on the balconies and so on. The Building Appeals Board dismissed the application by LU Simon, so the direction remains. However, LU Simon, as I understand it, have agreed during the course of the VCAT proceeding, which I'm about to come to replace the non-compliant cladding, and it will no doubt seek to recover the cost of doing so in that proceeding. The second thing that happened following the fire was that the Victorian Building Authority issued a notice to LU Simon to replace the cladding. LU Simon said, no, you can't do that, because under the Building Act in Victoria, you only have power to tell us to do things, to rectify works during the course of the works, and only up until the issuance of the final certificate, or the certificate of final inspection, or the occupancy permit. And that went to court, and the Victorian Supreme Court has found that they are right. So the Victorian Building Authority's notice to LU Simon has been withdrawn. There have, however, been significant amendments to the building regulations in Victoria, which are designed to overcome the problems that we have encountered with the cladding. I'll take you to them quickly, these ones, and you'll see that what's happening in Victoria now is that, pursuant to the regulations, the building surveyor must either have appropriate qualifications in relation to fire codes, or alternatively someone else is going to be certifying that the design complies. So let's go to the VCAT case. That might be interesting, I think, because we've heard what Mr. Corsaro has had to say about the building code and so on. It'll be interesting to see what the parties have said in that case about that. It's also interesting to see how the applicants have formulated their claims in circumstances where there's subsequent purchases, there's no privity of contract, and it's going to be difficult, I would imagine, to establish the relevant salient features to establish a duty of care to avoid economic loss. The claims are made by three corporate entities, being effectively the Owners Corp and the 137 owners of the apartments. They make claims against LU Simon, the builder, the first respondent, the building surveyor, second and third respondents, the architect, Fraser Eilenberg, the fire engineer, the fifth respondent, our friend Jean, and the superintendent, who's the eighth respondent. Damages are claimed totalling $15 million, $8 million of which is the cost of replacing the non-compliant cladding. The balance of that is things like reinstatement, loss of rent, and so on. So let's look quickly at the claims against each of those respondents. L.U. Simon, there's a claim made under the Domestic Building Contracts Act, which is the Victorian legislation which provides for statutory warranties in relation to domestic work. It's alleged against the builder that the material was not fire resistant, was not non-combustible, it didn't meet the performance criteria of CP2A 4 of the BCA, and didn't comply with the BCA because it did not to the degree necessary avoid the spread of fire. As you heard, the builder's response to that is, well, it's been used for 40 years and we've carried out the works in accordance with the building permit. Interestingly, the owners also make a claim under the Australian Consumer Law. The claim under the Consumer Law is in relation to a safety defect. Claim is under section 140 and 141 of the Australian Consumer Law. Broadly speaking, Section 7E of the ACL provides that the person is deemed to be a manufacturer if it imports the goods and the actual manufacturer, in this case the Chinese organisation, does not have a place of business in Australia. It's got to have a safety defect. That's governed by Section 9. I don't think there's any doubt that the goods had a safety defect. And then Section 141 and 41 go on to say that there's to be an entitlement to compensation if that safety defect in the goods causes damage to either other goods, Section 140, or to buildings, Section 141. In response to that claim, L.U. Simon says, we didn't import it and we're not a deemed manufacturer. They go on to say that it's not a safety defect. See paragraph A, this stuff's been used for the last 40 years. And it denies that it's caused the loss and damage and points the finger to the other respondents. Claims against the surveyor, claim made in negligence. There's a duty of care pleaded to avoid economic loss. Interestingly, the pleading is quite deficient in the way it goes about articulating how a duty of care arises in these particular circumstances. It's merely asserted that a duty of care is owed pursuant to the principles in the Victorian Supreme Court of Appeal case of Tatapanui, which established that a surveyor had a duty of care in the circumstances in that case. More particularly, the allegation against the surveyor is that he's negligently issued a building permit in circumstances where the design documentation did not meet the requirements, and that the surveyor has caused the loss and damage by giving approval for the design documentation and failing to require that the design documentation complied with CP2 of the BCA. There is also a claim against the surveyor under the ACL. In relation to the claim against the surveyor under the ACL, it's alleged that the issuance of the building permit constituted a representation which was misleading and deceptive because it represented that the design using the AC panels was compliant with the requirements of the BCA. It also says that it was misleading and deceptive to issue a certificate of occupancy. All of those allegations are denied by the surveyor. Interestingly, in the surveyor's defence, it pleads penalty privilege on the basis that it may be the subject of an inquiry before the Building Appeals Board. The architect, claim in negligence, not surprisingly. Again, there's only a mere assertion of a duty of care. It's not teased out how the salient features are to be made out. More particularly, it's alleged against the architect that it has failed to check the sample that was provided to it by L.U. Simon, and it's failed in its design of the cladding to ensure that it satisfied the requirements of the BCA. The architect in its defence denies duty of care. It denies that it was given sufficient information in order to be able to assess whether the cladding was compliant. It it denies that it approved the product as being suitable and in conformity with the requirements of the BCA. LU Simon, the contractor, has retained an expert who has provided a report in relation to the architect's specification and its subsequent approval of the Alucobest product, and says that that was negligent, and opines, amongst other things, that the generic specification, of just simply referring to AC panel, was not sufficient, and also said that it's not likely to be relied upon for assessing compliance with the performance criteria in the BCA, that the architect failed to refer the sample to other consultants, including the fire engineer. The fire engineer, the fifth respondent, claiming negligence, again a mere assertion of a duty of care not teased out. More particularly, it's alleged that the purpose and intent of the fire engineering report was to provide advice in relation to an alternative solution, meeting the performance requirements in the BCA, which requires that the building must have elements which will, to the extent necessary, avoid spread of fire, and that the report concluded and advised that the design of the building complied with the performance requirements of the CPA. It's then alleged that the fire engineer has breached its retainer by failing to make any proper assessment of whether the Alucobest product met the requirements of the BCA, and also failed to take into account the probability that tenants of the LaCrosse building would store flammable materials on their balconies. The storage of materials on these balconies was identified as a big problem by the Metropolitan Fire Board in this case. It's high density accommodation, there are too many people in these apartments, and they store all of their stuff out on the balcony. There's also an ACL claim made against the fire engineer based on the fire engineering report. The fire engineer, in its defence, says that it wasn't informed about the use of Alucobest and wasn't provided with a sample, and it hasn't specified a non-combustible material. It claims apportionment under the ACL in respect of the ACL claim, and says also that the ACL claim is time barred. Finally, the superintendent's sued in negligence. Once again, the duty of care is not properly articulated. As I said before, under the building contract, the superintendent was required to receive samples from LU Simon and approve them. In doing so, the specification also provided that the materials had to comply with the statutory authority codes, regulations, Australian standards, and other regulatory rules or bylaws. It's alleged against the superintendent that has breached its duty of care by approving the product and then allowing the installation to proceed during the construction phase. The superintendent, in its defence, says that its approval didn't relieve LU Simon of its design obligations. It had the full design obligation under its D&C contract with the developer, and goes on to say that, as I said before, that its approval was limited only to the colour of the product. The proceeding is scheduled to go to mediation in about August, and I think it's also scheduled to go to trial in about October, by which time LU Simon should have an understanding of what its costs are of replacing the non-compliant cladding. Just as a quick aside, there are disciplinary proceedings against the builder. The builder was found to have breached his obligations at the Building Practitioners Board. The surveyor is next, and then the fire engineer. Eilenberg Fraser was referred to the Registration Board of Victoria, the Architects Registration Board of Victoria, and the board found that there was no prima facie evidence to support the allegation of professional misconduct against the architect, which would warrant referral to the Architects Tribunal. Lastly, I won't dwell on it, I'll just give you some bullet points of the key items of legislation and cases in Victoria which, if you were to be involved in, you would need to go to. The first one is the Domestic Building Contracts Act. Sections 5 and 6 of that Act delineate the scope of the Act, what the Act applies to. it's clear now on the case law that multi-storey residential apartments are covered by the Act. You need to go to the case of Burbank Australia against Owners Corp 2015 VSC 160. In the provision which excludes work from the Act, there is a provision which says that those buildings which are not for the permanent habitation of residents are out. And recently His Honour Justice Digby gave consideration to what that meant in H Buildings against Owners Corporation 2017 VSC. That might be relevant, for example, if you have a building that might have originally been constructed to be residential or mixed use, and it's now being used for something other than habitation by residents. Second point, the case law now establishes that that Act applies to developers. Burbank Australia, again, provides authority for that proposition. Thirdly, there is compulsory domestic building insurance under the Building Act in Victoria. However, there's been a carve-out in the regulations in relation to multi-storey developments. Finally, the Limitations of Actions Act and the Building Act. There has been some confusion in Victoria until recently about whether or not the 6 years in the Limitations of Action Act applies both to contract claims and to tortious claims, or whether the Building Act extends the limitation period to 10 years in relation to both of those things, or only in relation to claims in negligence. That is, does it provide a long stop limitation period in respect of claims for economic loss? And in Briarec Industries against McKenzie Group Consulting, the Court of Appeal has found that it's 10 years for everything. That's all I want to say. Thank you very much. I hope that was of some assistance.
What that analysis of the Victorian case shows for us in New South Wales is that we get a lot by analogy. And what can we take away from that experience and from what we've heard? Firstly, it's almost inevitable that the focus of attention in establishing responsibility for the problems which are inevitable in New South Wales is going to shine the torch, firstly on the building certifiers, and secondly the design consultants, thirdly the contractors who are involved in the design and construct process, and the contractors generally for a reason to which I will come. When you look at this problem, you cannot ignore some of the findings of the Senate Select Committee set out in the interim report on this issue. The submissions that were sent to the Senate are replete with references to product substitution, where during the course of construction, compliant panelling has been substituted for non-compliant panelling to save cost, because it's just simply not possible to tell the difference without detailed testing, and that's not going to happen during the course of construction. I suppose one needs to look at that particular claim with a fair amount of scepticism, because when you look at the differential in cost saving between combustible and non-combustible panelling, there are two particular problems. The first is the cost is relatively insignificant. I think the evidence in the Grenfell Tower fire was that it cost £2 per square metre more for compliant rather than non-compliant material. But secondly, what is often lost in dispatches is that technically, if it's aluminium composite cladding, aluminium melts at temperatures well below the temperatures generated in a fire in its full glory. And the way that these things spread, I should have told you this earlier, but technically the way things spread, there are two ways that fires can be initiated on the cladding. The first is internally. What happens is, as you saw in the Four Corners film clip, it can start from outside where something like a cigarette or debris catches on fire. And in fact, one of those fires in Dubai, which I showed you earlier, actually occurred when someone was smoking a cigarette and threw it off a balcony. Originally, the people investigating thought it was a high up fire, but what actually happened is a guy threw a cigarette over the balcony. It hit some building debris, which was actually close to the facade. That caught alight and ran its way up the building. So it can either happen internally or externally. And the way it happens is internally, fire achieves a flash point, a flashover point, and that means that it bursts out and it laps outside openings like windows or doors, and it catches the light that way and up it goes. And that's why when you look at the way the Building Code of Australia operates, you might want to reconsider whether or not it is permissible, and people have been appropriately using cladding as being a mere adjunct or decorative panel, whether it ought to be considered as part of the facade. I know what I think the courts are going to hold if ultimately that point is ever taken. I can put a lot of money on the fact that they're going to say that that's an inappropriate view, but only time will tell, and I don't know whether they're even taking that point, but now David knows about it, he'll probably tell them. So that's the first point. The second point is that the other thing that one can't ignore is that when you look at the respective submissions made, the various responsibilities are likely to be shared amongst the participants depending on the circumstances. You'll need to inquire why did we have this cladding, where did it go wrong? And I've prepared a paper which I've titled Where Did We All Go Wrong? So to give you an idea, firstly, incorrect and misleading marketing by suppliers and wholesalers of product, and a misunderstanding of the designers as to how these things operate and what they actually get. The man with the, what did you call it, black skivvy. I'm sure I've acted for a lot of architects, and my late father-in-law was one, designing that brutalist building which has gone down around the corner. If I would have had asked him, how does this BCA operate in relation to fire prevention, in relation to cladding, he wouldn't have had a clue, and he was a really good architect. And I would hazard a guess that no building certifier that I know, certainly the ones that I've actually sued wouldn't know, but that how this thing operates. So it's understandable how these things have actually hit the floor and have made their place on buildings. The historic assumption, which I can tell you is true, I mean, the L.U. Simon position, the historic assumption, has been used for 40 years, and people have always been using this stuff, so what's the problem? Because the assumption's always been it's been used and it's compliant, and it's a safe and non-combustible material when it's far from the truth. Some are, some aren't. The complexity of the Building Code of Australia and who put that together. I mean, there's going to be obvious changes and amendments. They're percolating through in Victoria, and this is a national code, and it will, as a result of when all the dust settles on all these inquiries, it will change. Because seriously, to try and manipulate that, even as a skilled person who operates with that every day, I mean, David saw me trying to find the relevant provisions earlier today to bring down, and I just couldn't. And I've worked with them, and I actually advised on this issue. A company who was putting up cladding, asking whether or not the cladding was part of this. And let me just tell you, this issue, I advised in 2015 on this issue, well before Grenfell Towers. It's just Grenfell Towers has galvanised this point, and now people are actually thinking about it, and the authorities are actually very concerned about it because they see things like I've shown on the board, and they are wondering, gee, how did this happen? The other point, do not underestimate this alternative solution point that David sort of touched upon as being an issue in the LaCrosse litigation. The alternative solutions, some fire engineers hate them, some fire engineers just love them. And the alternative solution requirements merely require someone who has the knowledge to say, in my opinion, it's good. And generally speaking, the certifying authorities have taken that as being gospel. In the case in which I advised, that happened. The fire engineer let it go. The LaCrosse building happened, and then what occurred is the fire people got involved and said, hold on, we want this tested, and we want it tested to ensure deemed to satisfy compliance, and that's how I became involved. The gap in the ambiguity in the building code, not an issue in LU Simon. Trust me, it's an issue, and it was an issue which was submitted by the Institute of Building Surveyors, who submitted to the Senate. Everyone's blaming us, don't blame us, because this thing is really hard. We're just human beings, we can't work with it, we're being fooled, and we don't understand what it means. Now, this is the Building Surveyors Institute that's been saying this. So you can assume that the focus is going to be on them. Product substitution I've spoken about, incorrect, fraudulent, and inadequate documentation, dare I say, mostly associated with overseas countries providing certification, which simply doesn't make sense, and no one actually queries it. A lack of knowledge by the building practitioners and designers, and a lack of on-site supervision, witness the issue in relation to sample. But dare I say, even if the samples have been provided, they're not going to tell you this, but even if the samples had been provided, they wouldn't have known what to look for, because they wouldn't have known what the tests are, and they wouldn't have known what the documentation regime is for the Australian standard, because it's a really complicated piece of legislation. Now, all of that stuff is stuff that we'll need to consider. There are time issues in New South Wales. There are issues about when did the building get approval? Does Section 109ZK apply? Is there a long stop? Do we have a building action anyway if there's a long stop? There's a certification issue, and I've given advice in respect of other products where, for example, we might have been time barred, we might not have had a duty of care, but certificates have been presented to a certifier who's issued an occupation certificate, that's passed the liability, third party misleading and deceptive conduct, and that ain't a long stop. So all of these issues are issues that are relevant, they're complex, but hopefully today's discussion has given you some basic and good understanding as to how to deal with it when people come, as they will, knocking on your door to inquire about the issue. Thank you very much. We're a little over time, but I'm happy to take any questions, and David, no doubt, is happy to take questions if you have them. Silence is acknowledgement of nothing. Please feel free to enjoy the drinks.